Well, I think we should probably make a start, if that's okay. Good morning, everyone. Welcome to this seminar on the recent much vaunted decision of the Supreme Court in Triple Point Technology and PTT Public Company, 2021 UKSC 29. I'm Andrew Singer, and with me is Sarah Lawrenson, and between us we're going to talk about the three issues that arose in this case for about 20 minutes each, and then there should be some time for some questions, and we're hoping to wrap up by 10 o'clock, if not, in my case, marginally earlier. But if matters go on after 10, Sarah, I'd be happy to carry on and answer any Q&A. I'm sure everyone by now is very familiar with the Q&A functions and the like, and they'll be monitored throughout. So get the technology to work, which is unlikely. I'll start. So there were three issues in this appeal. The principal issue, the one I'm going to talk about, is what's described as the availability of liquidated damages issue. And that was whether PTT was entitled under the contract between the parties to liquidated damages for delay for work which hadn't been completed before the contract was terminated. The second and third issues arise from part of the main contract, which imposes a limit, or what judges described as a cap, on the amount of damages which could be claimed for breaches of contract. So the second issue, which Sarah is going to speak to, is the cap carve out for negligence issue, which is whether an exception from the cap in the contract for negligence removes losses from the cap caused by a negligent breach of contract, or only losses for the commission of some what's described as an independent tort. And then the third issue, which didn't really trouble the scorers that much in the Supreme Court, the capping of liquidated damages issue, is whether liquidated damages fell within the cap on liability as a matter of quantum. So the contract between the parties was a software contract, known as the CTRM contract. It was dated the 8th of February 2013 and made between the parties for design and installation by data transmission, maintenance and licensing of software to assist PTT to carry on its commodity trading business. And Triple Point needed to customize proprietary software for commodity trading and risk management to PTT's needs. And its payment under the contract was by reference to so-called milestones set by the contract at which specified work can be done and steps completed. That's, as you all know, not an unusual situation. Triple Point also agreed to enter into maintenance, upgrade, replacement, online support and staff training obligations, and to enter into a perpetual license. The perpetual license terms, which form part of the CTRM contract, was based on a standard full license agreement and had various warranties as to quality of software, and they were annexed to the main part of the CTRM contract. There were also provisions for checking the software provided confirmed specifications. So that means it achieved the agreed functionality or purposes or range of functions. And it's obvious that this was, said the Supreme Court, an important part of the contract, and software defects could cause enormous financial or other harm to PTT. So what I'm going to talk about is the liquidated damages issue. Now, I'm sure everybody knows what liquidated damages are, but it might help if I read out or summarise what Lord Leggett, who gave one of the main joint judgments in the Supreme Court, had to say about liquidated damages clauses, because it's quite neat, and this is at paragraph 74. The judgment. I should say the slides are before you are quite limited in amount of words, but there are notes that accompany the slides, and they will be emailed out after the seminar to attendees. I should also point out, as you probably already realised, and it's already started, that this event is being recorded. So Lord Legate describes a liquidated damages clause as a clause in a contract which stipulates what money will be payable as damages for loss caused by a breach of the contract, irrespective of what loss may actually be suffered if a breach of the relevant kind, typically delay in performance of the contract, occurs. Liquidated damages clauses are a standard feature of major construction and engineering contracts, commonly provide for damages to be payable at a specified rate for each week or day of delay in the completion of the work by the contractor after the contractual completion date has passed. Such a clause serves two useful purposes. First, establishing what financial loss delay has caused the employer would often be an intractable task capable of giving rise to costly disputes. Fixing in advance the damages payable for such delay avoids such difficulty and cost. Second, such a clause limits the contractor's exposure to liability of an otherwise unknown and open-ended kind, while at the same time giving the employer certainty about the amount it will be entitled to recover as compensation. Each party is therefore better able to manage the risk of delay in the completion of the contract. So that is the theory, pausing there, of course, to notice that this contract, which contained a liquidated damages clause, which was supposed to make it easy to establish your financial loss and easy to limit your exposure, ended up in the Supreme Court with the parties arguing about what it provided, what it meant, and the rest of it. But that's life, I suppose. So what did the contract provide? Well, the relevant clause of the contract is Article 5.3, and that said if, and although, it should be pointed out that although this contract was being performed in Southeast Asia, it had an English law contract, and that's why it ended up being litigated at first instance in the TCC in London, and then going through the UK court. If contractor fails to deliver work within the time specified, and the delay has not been introduced by PTT, contractor shall be liable to pay the penalty at the rate of 0.1% of undelivered work per day of delay from the due date for delivery up to the date PTT accepts such work. Now, you will have noticed that when I read that clause out, it included the word penalty, and everybody knows that penalties are unenforceable. But despite the fact that the parties referred to the clause as penalty, it was agreed that it wasn't a penalty, but it was a liquidated damages clause. So it's if the contractor fails to deliver work within the time specified, the delay has not been introduced by the employer, the contractor pays 0.1% of undelivered work per day of delay from the due date for delivery up to the date PTT accepts such work. Now, the Court of Appeal decided that if Triple Point doesn't complete the work at all because its contract had been lawfully terminated because of its own repudiatory breach, then there is never a date when PTT accepts the work, and therefore there is no liability to pay any liquidated damages. So that clause is effectively made redundant by the lawful action of the employer repudiating the contract, accepting a repudiation of the contract based partly, if not exclusively, on delay. So how did the Court of Appeal come to that decision? Well, they, in the form of Sir Rupert Jackson, who is, of course, a highly regarded, esteemed construction specialist judge, relied on a decision of the House of Lords in 1913 called British Glasnost Manufacturing Company Limited in General Accident. And he said, at paragraph 112 of the Court of Appeal's decision, let me now turn to Article 5.3 in the present case. This clause, like Clause 24 in Glasnost, seems to be focused specifically on delay between the completion date and the date when Triple Point actually achieves completion. The phrase in Article 5.3, up to the date PTT accepts such work, means up to the date when PTT accepts completed work from Triple Point. In my view, Article 5.3 in this case, like Clause 24 in the Glasnost case, has no application in a situation where the contractor never hands over completed work to the employer. Well, what did the Supreme Court make of that? The first main judgment in the Supreme Court was given by Lady Arden, but it was a joint judgment with two other lords. And she thought that that approach was wholly incorrect. She said that the difficulty with the approach was it's inconsistent with commercial reality and the accepted function of liquidated damages. And in line with what Lord Legate said, she says this: parties agree a liquidated damages clause to provide a remedy that's predictable and certain for a particular event. The employer doesn't then have to quantify its loss, which may be difficult and time-consuming. Parties must be taken to know the general law, namely that the accrual of damages comes to an end on termination. So there was no dispute that once the contract was terminated, the liquidated damage provision ended, and then there was a claim for general damages for delay going forward. But here what was said was that the pre-termination damages went as well. After that event, parties' contracts at an end, and parties must seek damage of breach of contract. That is well understood. Parties don't have to provide specifically for the effect of termination of their contract. They can take that consequence as read. I do not therefore agree with Sir Rupert when he holds that if a construction contract is abandoned or terminated, the employers in new territory for which the liquidated damages clause may not have made provision. Lady Arden says the territory is well trodden and the liquidated damages clause does not need to provide for it. And then she said, of course, the parties may, out of prudence, provide for damages to terminate on completion liquidated damages on acceptance of the work to avoid remove any question of their being payable thereafter. But if they do, it's unrealistic to interpret the clause as meaning that if that event doesn't occur, the contractor is free from all liability for liquidated damages, and the employer's accrued right simply disappears. It's much more probable they will have intended the provision for liquidated damages to cease on completion and acceptance of the work to stand in addition to, and not in substitution for, the right to liquidated damages down to termination. Reading the clause in that way meets commercial common sense and prevents the unlikely elimination of accrued rights. The Court of Appeal was aware of the importance of accrued rights because Sir Rupert said, although accrued rights must be protected. However, the rest of that sentence and the next sentence go on to hold that it may be the parties intended general damage should take the place of liquidated damages. Quote, it may sometimes be artificial and inconsistent with the parties' agreement to categorise losses up to a date and then general damages. It may be more logical and consonant with the parties' bargain to assess total losses, applying the ordinary rules. That's what Sir Rupert said, but Lady Arden says if that was so, it's hard to believe the parties would have gone to the trouble of providing for liquidated damages in the first place. Moreover, under this approach, accrued rights are not protected, they are lost. And then dealing with the Glasnost case, Lady Arden said, nor do I consider that the little-known case of Glasnost should have led the Court of Appeal to radical reinterpretation of the case law on liquidated damages clauses. In my opinion, in my judgment, Glasnost is a decision on the interpretation of a particular contract. Although the Court of Appeal treated Glasnost as a case of significance, it is not. And then she said, to use an idiomatic phrase, the interpretation accepted by the Court of Appeal in effect threw out the baby with the bathwater. So that was Lady Arden. And then Lord Legate, agreeing on this at 92, he gave us judgment which was joined in by with Lord Burrows, who, as most of you or all of you will probably know, is the expert on restitution and construction of contract. Lord Legate said the interpretation contended for by a triple point is unaccepted by the Court of Appeal. If triple point never completes work because PTT terminates the contract, because then there's never a date when it accepts the work, and in those circumstances, liability to pay liquidated damages has no application. This seems to me to have the double disadvantage of being inconsistent with the language and the commercial purpose of the clause. It's inconsistent with the language because the clause specifies the conditions must be met for liability to pay damages to arise, and acceptance of the work by PTT is not one of them. The clause doesn't say the contractor should be liable to pay the agreed sum for each day, provided PTT accepts the work or anything of that kind. It simply makes the contractor liable to pay that sum for each day of delay up to the day PTT accepts the work. This carries no implication that the contractor will not have a liability to pay damages for delay unless such a date arrives. To the contrary, the clause clearly signifies that provided two stated conditions are met, liability to pay the agreed sum for each day of delay will run from the due date of delivery and will go on running until the work is terminated. That's the effect of the clause, no more and no less. If the contract is terminated, the liability to pay liquidated damages stops running, not because the end date specified in the clause has been reached, but because Triple Point ceases to be under an obligation to deliver work with which it is failing to comply. So the Supreme Court have gone back to what is often described as the orthodox approach. And that all seems very sensible. One point that may be thought of is what in that context does up to the date PTT accept such work actually mean in that contract on the Supreme Court's interpretation of it. And I'm not, for my own part, with the greatest respect, I'm not saying the decision was wrong, but I'm not quite sure that the Supreme Court ever really grappled with that point. But nevertheless, they did grapple with the rest of it, and they were certainly not impressed with the approach which the Court of Appeal had taken on this point. So that in 15 or 20 minutes is a quick run through of point one. As I said, notes will follow, and you can read for yourselves at leisure some of the more important paragraphs of the judgment. I'll now hand over to Sarah. Thank you.
Yeah, looks like it. Apologies all, I'll just try and share my screen so that the slides can continue. Thank you, Andrew. Yes, the next point that arises in the Supreme Court judgment is that has become known as the cap carve-out issue. As has been said, the cap carve-out arose from another article in the main contract, in this case 12.3, which imposed a limit or a cap on the damages which PTT could claim for Triple Point's breach of contract. The issue then was whether an exception from the cap in Article 12.3 for negligence removed the cap losses caused by TP's negligent breach of contract, or only the losses for the commission of some independent tort. Apologies, I think perhaps I'm having technical difficulties here. I'm not sure you can see what I'm moving on to. So what did the contract provide for? Well, Article 12, which was headed liability and responsibility, began at 12.1 that the contractor should exercise all reasonable skill, care and diligence and efficiency in the performance of the services under the contract and carry out all responsibilities in accordance with recognised international professional standards. Then significantly 12.3 was comprised of 4 sentences. And Lady Arden went through these 4 sentences in detail and referred to them by their individual sentences. 1, the contractor shall be liable to PTT for any damage suffered by PTT as a consequence of the contractor's breach of contract, including software defects or inabilities to perform fully complies or partially complies functionalities as illustrated. Sentence 2, the total liability of contractor to PTT under the contract was to be limited to the contract, and then a formula in relation to the price received by the contractor. The third sentence then, except for the specific remedies expressly identified as such in this contract, PTT's exclusive remedy for any claim arising out of the contract will be for the contractor, upon written notice, to use best endeavours to cure the breach at his expense, or failing that, to return the fees paid to the contractor for the services or deliverables related to the breach. The fourth sentence, this limit of liability that we've just seen in sentence 3 shall not apply to the contractor's liability resulting from fraud, negligence, gross negligence, or willful misconduct of contractor or any of its officers, employees, or agents. So the Court of Appeal decision. The Court of Appeal held that the exception to the limitation on liability for breach of contract for negligence did not apply to cases where Triple Point was liable for a breach of a contractual obligation that we saw in 12.1, namely to exercise reasonable skill and care, and that the exception on limitation only applied to freestanding cases of tort or deliberate wrongdoing. And in those circumstances, it didn't apply here. The Supreme Court decision was a majority decision, with Lords Sales and Hodge dissenting on this issue. So the decision of Lady Arden for the majority held that liquidated damages are within the cap carve-out in the fourth sentence of Article 12.3 if they result from breaches by Triple Point of its contractual obligation of skill and care, so that liability for them is uncapped. This limitation of liability shall not apply to contractors' liability resulting from fraud, negligence, gross negligence, or willful misconduct. The first point to make, said Lady Arden, is that the word negligence has an accepted meaning in English law, which was the governing law of the CTRM contract. As Andrew has said, although this contract was not to be performed within the English jurisdiction, the governing clause meant that English law applied, and the Supreme Court, through Lady Arden, considered that the use of the word negligence therefore had the English law meaning of that. And she found that it covered both the separate tort of failing to use undue care, failing to use due care, and also a breach of the contractual provision to exercise skill and care. Unless, therefore, some strained meaning can be given to the word negligence in the context of the final sentence of Article 12.3, the effect of the clause is that the liability for negligence does not exclude the breach of a contractual duty of care. Second, that the contract was not solely about the provision of services, but it was held also included important obligations on Triple Point's part for the provision of defect-free software and deliverables. It was clear from the opening sentence of Article 12.3 and the reference in Article 12.1 to recognised international professional standards that there were certain matters which Triple Point agreed to do or to provide as an absolute covenant, not merely one of skill and care, and that those matters included the agreed level of functionality. Thus, in the first sentence of Article 12.3, there was an obligation to provide software which met the specifications as to functionality. Third, unless there is an obvious example of an independent tort, it was unlikely in Lady Arden's judgment that the parties considered that the word negligence should apply, and on Triple Point's case, apply only to an independent tort. It was said that no one could come up with a realistic example of such tort, and Lady Arden discussed the examples that have been given by Sir Rupert Jackson in the Court of Appeal, and also by counsel appearing in the Supreme Court. For examples, injury caused by wiring should somebody attend at the premises, and found that they would be outside the contract anyway, and therefore could not be said to be part of the limitation of Article 12.3. Paragraph 63, Lady Arden said that the Court of Appeal went down the wrong route in concluding that the word negligence in the cap carve-out referred to an independent tort. The matters referred to in the final sentence are all characteristic of conduct, fraud, willful misconduct, gross negligence, and negligence itself. These can apply to breaches of the CTRM contract, and considering that sentence as a whole, it is clear that it includes an act which is a breach of contract and which possesses one of those characteristics. Thus, if there is a breach of contract to exercise skill and care by reason of Triple Point's negligence, that will not be subject to the cap in Article 12.3. It is simply the provision of deliverables and other obligations of result under the CTRM contract which fall within the cap. Lady Arden said that as she had explained, in a software contract where the provision of software may result in damages of a considerable amount without any fault on the part of the designer installer of the software, it is understandable that claims for damages for breach of the requirement that subject be defects free should in those circumstances be subject to the cap. And therefore, the first instance judge, Sir Rupert Jackson, and the Court of Appeal were wrong to treat damages for the breach of the contractual duty of skill as subject to the cap. Lord Leggett also grappled with this point and said that negligence was sufficiently clear to include a contractual duty, and he was unimpressed at the submission of other categories that would give the clause some meaning. The starting point must be that, as Mrs. Justice Jefford at first instance had observed, any breach of an obligation to exercise reasonable care and skill would in the common legal language be negligence, whether the source of that obligation is a term of the contract or the law of tort. And on the straightforward reading of Article 12.3, liability resulting from a breach of contractual duty falls within the exception of liability resulting from negligence. Hence, such liability is not subject to the limitation of liability of triple point to PTT. At paragraph 101, it was said that a further compelling reason to give the word negligence in Article 12.3 its straightforward and ordinary legal meaning is that it had already been noted that Article 12.3 only deals with liability for a breach of the contract and does not deal with liability in tort generally. It therefore makes no sense to interpret the word negligence in sentence 4 as referring to a basis of liability which is not part of the subject matter of the clause, namely the cap imposed in sentence 2. And therefore that applied to the total liability of the contractor under the contract. It does not apply to any other liability which the contractor might have independent of the contract and arising from the law of tort. The only limitation of liability resulting from the negligence which Section 4 can disapply is liability resulting from a breach of a contractual duty of care. Liability in tort does not even enter the equation. It was said that no reasonable person would understand the word negligence to mean negligence which is neither a breach of a contractual duty of care nor of a concurrent duty in tort. And at paragraph 106, even if the interpretation for which triple point contends were considered to be a possible meaning of the word, a further reason for giving the word negligence its straightforward and ordinary meaning, legal meaning, is that clear words are necessary before the court will hold that a contract had taken away any valuable rights or remedies which one of the parties to it would have had at common law or pursuant to statute. The next 4 or 5 paragraphs then deal with the law in full on this point and concludes at paragraph 111 with a discussion of the contra preferentum rule and that the modern approach being that parties need clear words to remove a party's liability for its own breach. However, this was a majority decision and therefore we have the dissent of Lord Scales, with whom Lord Hodge agreed, in particular at 132, and said that they were following 4 experienced judges, of course the 3 Court of Appeal judges and Mrs. Justice Jefferson. If the word negligence in the 4th sentence is construed as applying to breaches by triple point of its obligations to exercise reasonable skill and care in carrying out its tasks, it would effectively nullify the limitation of liability in the 2nd and 3rd sentences. That limitation of liability would then only apply in relation to non-negligent breaches of any strict obligation in the CTRM contract. But there are very few, and with the exception of warranties as to the use of intellectual property rights, and they were ancillary or peripheral to the main performance obligations under the contract. It was said that although Lady Arden regards the obligations of triple point regarding the provision of defect-free software and deliverables under the contract as strict, it was not considered that that was right. They are part of the services as defined under the contract and according by virtue of Article 12.1 are subject the subject of a performance obligation of reasonable care and skill. In Lord Legate's, in the dissent, it made no sense to interpret Article 12.3 as giving on one hand and taking away with the other, and that it was said it could only sensibly refer to tort as something apart from the normal commercial relations under the contract. So what we see here is that Triple Point were able to persuade 6 of the 9 judges and still lose. But there we are, that is the Supreme Court. Moving on then to the third issue, which was the capping of the liquidated damages issue. And again, this rose from the same Article 12.3 and was an issue as to whether the liquidated damages, which of course Andrew has spoken about, fell within the cap on Triple Point's liability. In the Court of Appeal's decision, it was said, in my view, the way in which, this is paragraph 127, the way in which the contract works is this. Number 1, Article 5.3 provided a formula for quantifying damages for delay. 2, sentence 3 of Article 12.3 deals with the breaches of the contract not involving delay. Hence, sentence 3 necessarily includes the word except for the specific remedies expressly identified as such in the contract, it being common ground that this phrase refers to liquidated damages under Article 5.3, and sentence 3 of Article 12.3 imposed a cap on the recoverable damages for each individual breach of contract. And then at 3, sentence 2 of Article 12.3 imposes an overall cap on the contractor's total liability. That cap on total liability means what it says. It was said in the Court of Appeal. It encompasses damages for defects, damages for delay, and damages for any other breach. Apologies, I can't. Yeah, there we go. So the Supreme Court decision, again, Lady Arden at paragraph 71, she agreed with the Court of Appeal that a reasonable assessment can be made of the relevant part of the price. However, she did not accept that the exception for special remedies in the third sentence extended to the second sentence dealing with the global cap. And her interpretation, the second and third sentences of Article 12.3 serve separate functions, are in a logical order. First, there is a limitation on liability, and second, there is a limitation on the form of remedy. The limitation on the form of remedy contains an exception for special remedies under the contract, of which the liquidated damages clause would be one. But that does not mean to say that the same exception could be written into the limitation on liability. The appeal was therefore dismissed on the basis that the Court of Appeal were right to say that the cap embraced liquidated damages so that they could count towards the maximum damages recoverable under the cap. In summary then, at first instance, Mrs. Justice Jefford had found that PTT were entitled to damages for breach of contract on termination of just shy of $3.5 million in respect of liquidated damages prior to termination, and $630,000 in respect of wasted costs of hardware pre-termination, and then $10.5 million in respect of termination losses. Liability for damages in respect of wasted costs and termination was then capped at $1 million by Article 12.3. The Court of Appeal held that PTT were entitled only to liquidated damages in respect of works completed, together with an entitlement to general damages on termination, again subject to the cap in Article 12.3. But what was the overall result here? Well, Lord Legate found that PTT was entitled to recover the damages assessed by Mrs. Justice Jefford in the total sum of some $14.6 million without any limitation on liability. I think we still have Andrew here. I know he has to shoot off. I don't think, Andrew, I've seen any Q&A or any chat questions.
Likewise, sorry. I haven't seen any either, which I'm sure is a tribute to at least your clarity on these subjects. So, unless there are any questions suddenly coming into the Q&A, we can perhaps draw the threads together with a couple of observations, if I may, on where this takes us, ramifications going forward. Obviously, for those who are watching who are non-contentious lawyers who are drafting liquidated damages clauses or incorporating liquidated damage clauses into contracts every day of the week, the return to orthodoxy is probably welcome. Equally well are the helpful drafting guidance by all the members of the Supreme Court on how you would avoid the orthodox approach if that's what you ever choose to do, by making it perfectly clear that that's what you're doing. So first of all, the first lesson to take home, I suppose, is to be, when you're drafting the clauses and advising on what the clauses mean, look to the language and look to this recent case, which will help on that. The second take home, I suppose, is if you are telephoned or I suppose these days Zoomed or Teamed by a client, whoever they are, employer or contractor, who wants to know whether they can terminate the contract and what will happen if they do. On the basis that the termination is lawful, you will obviously now need to give advice on what happens to the liquidated damages when the termination occurs. And you may also want to think about whether that replaces an obligation to pay liquidated damages, which are in some cases perhaps quite generous, and replaces it with an obligation to prove losses, which might not be as generous and might be more difficult to do. In other words, in appropriate cases, you might take the view that rather than terminating, you simply keep taking the liquidated damages. Obviously, that's going to be subject to whether there's a cap on liability, as there was in this case, because you get to a stage where you run out of funds, and then you will have to terminate to get to the uncapped post-termination general damages. So those, I think, for me, are two take-home points. The third is that, not surprisingly, perhaps, the Supreme Court did return to the orthodox view espoused in, for example, Keating on construction contracts and the other major textbooks. I don't know if Sarah has also got any points she wants to make. She already quite properly made the point that in one of the decisions, despite getting 6 of 9 judges, nevertheless, triple point still lost. But that, as they say, is the way it goes. I can report that there isn't any Q&A that's come through to us or any chat functions. If there are any questions that arise when you receive the notes or later and you want to email Sarah or I, please feel free to do so. Thank you very much for your time this morning. I hope it's been a useful and helpful seminar. As you know, we're very grateful to you for turning up and tuning in and listening, because without you, this really would be a pointless exercise. And we hope you've enjoyed it. King's, as you know, puts on many seminars, and there are others coming, which we hope you'll also join us at. And there will be more construction seminars. Oh, we've got one. Just one person, thank you. Welcome. We have more construction seminars coming in due course. But with that in mind, thank you very much for attending. Hope you've enjoyed it, and stay well and have a good weekend. Bye.